Okay, good morning and welcome to Coffee with the Commission, a time where the WMC discusses topical issues that affect you. Today, we will be talking about the 2024 legislative session thus far and key legislation that may affect healthcare. Today, I'm joined by Deputy Executive and Legislative Director Micah Matthews and Stephanie Mason, WMC Public Information Officer and Legislative Liaison. Before I turn the webinar over, I want to take care of a few housekeeping items. We encourage you to ask questions throughout the presentation, so look for the question button or use the chat box within the Teams framework, and we'll do our best to address your questions at the end of the presentation. We are recording this webinar, and it will be available on our website within the next few days, so please feel free to share these resources with your friends and colleagues. So with that out of the way, I'm going to turn it over to Ms. Mason.
Good morning. As Jimmy said, I am Stephanie Mason, and I'm the Public Information Officer and Legislative Liaison. We can dive in with the first slide. Jimmy, thank you. So as you can see here, the WMC is involved with the legislative session, and even though we are a regulatory body, we're not allowed to lobby per se, but we are allowed to educate lawmakers, and in that sphere, we track, monitor, analyze, and partner with the DOH throughout the session, both independently and with them. We testify on bills, we meet with legislators, and help educate all stakeholders on the legislation that's beneficial or detrimental to the practice of medicine, which is key for all of our licensees. Next slide. I won't spend a lot of time on the legislative process. This is just a rudimentary graph to let people know who possibly don't know about the legislative session, the path that bills go on once they are introduced. When bills are introduced by a lawmaker, they start in a policy committee, and then they go from fiscal committees to rules to the floor for a vote. And that's, like I said, very rudimentary. There are other steps in there sometimes. And then they go to their opposite house, which is kind of what we're doing with the arrows here, and they start that process again. So Michael will talk to you later about cutoffs, but bills have to make it through this process in order to make it all the way to becoming law. The cutoffs will sometimes stop a bill in policy or fiscal or rules. The most important committees for the WMC are the House Healthcare and Wellness Committee, the Senate Health and Long-Term Care Committee, and then this year and last year, the Post-Secondary Education and Workforce Committee, which addresses compacts in our state, of which we have a PA bill this year that is going through that committee. And now Micah will explain to you a little bit more about the legislative session and the process.
Good morning. Just for some background, I wanted to provide a couple of links to videos to further explain how a bill becomes a law, because there is some nuance there. So this is one of these is the official Washington State Legislature link. The other one is a throwback from when a lot of folks were kids on PBS, and it has the Mr. Bill thing. So next slide, please. So right now, we call it the mad dash. We're just going towards cutoff. We've already experienced the policy and the fiscal cutoff for what's called the House of Origin. So basically, if a bill started in the Senate, it had to get through its policy committee. It had to get through its fiscal committee if there was a fiscal impact of the bill. And now they're trying to get the bills through rules and off the floor and send them to the opposite house. So you can see the dates there. This is a short session, so those dates are pretty tight. NTIB means necessary to implement the budget. Those bills can be introduced at any time. And so they don't really have a cutoff applying to them always. And we've seen some bills magically come back that were designated as necessary to implement the budget, although that was fairly questionable at those times. Next slide, please.
I think it's back to me. As you can see here, we track a variety of bills, and so does the Department of Health. The Department of Health has more bills than we do, as they have several professions to regulate. The WMC only tracks bills that directly impact the practice of medicine, or MDs and PAs. However, this session was very interesting because, unlike last session, many bills were pre-filed, and for a biennium, that's pretty rare. Normally in a biennium, bills that are necessary to implement the budget or budget related are the focus. So this year it was kind of a surprise that we had significantly more bills pre-filed and introduced as new legislation instead of reintroduced. I didn't go over that in the process as much, but during the second part of a biennium, if a bill was introduced in the beginning, it can be reintroduced in its present status, and it can go from there in that cycle. So there's been quite a few of those bills as well that have been reintroduced. As you can see, there were 3,481 bills introduced. As they're going through the process, that is getting culled down. I believe last year there was about 300 bills passed into new laws. So we'll see how that goes for this year. I believe it's over here in the graph that you can see how many were passed last year. And then in total in the biennium, that number will increase. So for us, we're tracking 63 bills. Micah will cover some of those later, only a small portion that we've testified on and are really following very closely. Next slide. This is a broad overview of the types of issues we track each session. There's got to be a reason for the medical commission to get involved in legislation, obviously. But for us to step up and testify, it usually has to include one of these concepts where it directly affects our Practice Act or directly requires the medical commission to be responsible for enacting some part of the legislation, such as a work group or a new license, or bills that could negatively impact the practice for the public. I don't think we cover any of those here, but we'd be happy to take questions about those. Most of these are self-explanatory, so I won't go into them in full detail, but legislating the practice of medicine is a frequent one where we feel the legislature is attempting to mandate what a physician or a PA could actually do in their practice, telling them how to care for a patient. That should normally be left up to the judgment of the practitioner and not be spelled out in law. Next slide. And I think we're back to Micah.
Thanks, Stephanie. Yeah, so we have some principles that we go by that determine, as Stephanie said, whether we get involved, what positions we may take, and as the regulatory authority for physicians and physician assistants in Washington, we rely quite a bit on things like our authorizing environment. So that's the Medical Practice Act, the Uniform Disciplinary Act. Not to say that we reject any change that would come to those two particular acts, but they guide what comes after, which is the rulemaking that the medical commission implements. They can do rules, interpretive statements, they can do bylaws that govern the commission, policies, and then less forceful are the guidelines or position statements and procedures that we use. So the additional piece is how and this is more of an X factor piece of how the commission actually functions as an organization. We also have staff mandates in the form of union collective bargaining agreements, and then just general budgetary needs. We have an active legislative subcommittee that gets rundowns every Friday of bills that we're tracking and just the proposed positions that we're taking. They also, a couple of them participate on the weekly calls with DOH, who reviews bills of interest to the regulatory boards and commissions. We also have clinical specialists for those bills that get introduced where Stephanie and myself we are not clinicians. And so there are things that we don't fully understand. We're thankful that a lot of the bills are written in plain English, but there can be some legal or clinical implications. And in those situations, usually around psychiatry, that's one that we usually do, but there are specialty issues like ophthalmology versus optometrist, or scope of practice issues where we're not totally clear on the training, and so we utilize our clinical specialists in the form of our commission members, our pro tems, or we have some clinicians on staff that we consult as well. And then overall is we're looking at patient safety in the healthcare system. That's our true north, our guiding star with respect to how we approach bills. And at that point, we also look at how the impact of the practice environment would occur with a bill to our MDs and PAs that we license. So we do try and make sure that there's a overall permissive and positive practice environment in Washington, because we know that can impact whether folks choose to come here or not to practice. Next slide, please. So bills that we're looking at. So I'm going to start over on the right-hand side and just touch on a couple of these. So prescription labels for abortion medications, that one I believe is still moving, and that would allow practitioners who are prescribing abortion medications to not necessarily have their name on the prescription bottle. This is more of a security thing. So they're proposing allowing just using the NPI or National Practitioner Identifier number on there. Anesthesiologist assistants, that would create a new profession under the regulation of the Washington Medical Commission of Certified Anesthesiologist Assistants working with MD or DO anesthesiologist with direct supervision. That passed off the Senate floor yesterday. So we're going to see that go through the House now in the process. The Uniform Telemedicine Act was reintroduced and amended, and that passed off the Senate, and now it's in the House Healthcare Committee. So we're supporting of that. That would essentially establish a uniform telemedicine policy or telehealth policy for all professions in the state, and that's something that's been sorely lacking. If you've been following this, most of the regulations of telehealth exist in the insurance code, not in the Practice Act. So this is a huge leap forward. It's also largely based off the it's from the Uniform Laws Commission, but it's largely based off of the telemedicine policy of the Washington Medical Commission. And then there is a telehealth telemedicine insurance regulatory update in the form of 5821, which would define how, for payment purposes, the relationship with the patient is established for audio-only telemedicine coverage. And moving over to the left-hand side, we've got a late-breaking change with respect to Senate Substitute House Bill 1300. Some of you may be familiar with some of the disciplinary actions that the Medical Commission has taken, and recently we took action against a practitioner and took their license for assisted reproductive fraud, put another way, using their own genetic material in assisted reproduction and fertility services. So that bill was pulled from rules yesterday. It's on the House floor. We anticipate there will be an amendment on it, and we anticipate that it will ban the practice in the Uniform Disciplinary Act of providing your own genetic material. We are supportive of that. The compacts, physician assistant compact, both in the House and the Senate, have passed out of the respective houses, and those are progressing. I would anticipate that Washington State will pass the physician assistant compact, and once 7 states adopt that compact, it will go active. 24 months after that, it should start issuing licenses. There's also a couple of WPHP bills. One is a licensure fee, and the other one is, I believe, dealing with records, but we're just going to talk about the licensure fees. It's been 10 years since the surcharge has been increased for WPHP, and so they're trying to increase that surcharge, I believe, by $20 for various professions. We are supportive of that bill as well because we rely pretty heavily on WPHP for dealing with issues that the Medical Commission is just simply not equipped to deal with, which is substance abuse, mental or physical health issues that require monitoring. And then finally, the Medical Association has put forward a bill related to physician wellness programs. That's still very much in negotiation. Even this morning, we were sending back some suggested language to clean it up and try and make it a workable thing. To break it down, there's the physician health program, and they handle the impaired and the folks who have mental or physical issues that require monitoring. You have the disciplinary side where the Medical Commission operates, and usually we will try and refer people to WPHP so they can get treatment. And then there's this wellness piece that deals with burnout and medical issues that are not resulting in impairing someone's practice. That's where the wellness program is envisioned to exist. And so we're supportive of that concept so long as we can get it right. The trick is there's a very fine line between what the physician health program does and what the wellness program would do, as well as where the referral lines are for the regulatory authority that is the Medical Commission. So we are watching that very closely and working with WISMA to try and make sure that lands pretty well. And I believe that's all for this slide. Any questions on the update?
So if anyone has questions, feel free to use the chat, raise your hand. There's also a question portal if you click more, but feel free to speak up and ask any clarifying questions you might have about this session. Thank you so much to both of you for presenting this. It was really helpful. There's a lot of stuff moving, and I learned some things today about where the practice of medicine is headed. Is there anything that you think isn't directly related to WMC legislation or requires our involvement, but that licensees and stakeholders should be aware of, just to kind of keep on their own radar?
Yeah, I think there's a couple of things we can look to. The first one is we're participants and facilitating the International Medical Work Group, International Medical Graduate Work Group. That's been ongoing for 5 years. This is the final year, and it will be the final report this year. We're hopeful that we will have some pretty positive recommendations. We've achieved pretty much everything that the bill set out for us to do. And we even reconsidered some things like trying to figure out how to do a hardship waiver. For those who are not following the GME and the testing and the international certification pieces, there's a bit of a scandal going on right now with the U.S. medical licensing exam, where there's a massive cheating ring discovered in Nepal, and we've seen about 800 test takers and ECFMG certified folks have their scores invalidated. They are able to go back and retest to prove that they can pass, but the fact that Nepal had something like 85% of the people scoring above 270 was a pretty huge standard deviation away from the mean. So we know that that's not impacting our licensees or residents directly, but there's always the possibility that we see legislation dealing with that. In the same breath, we're looking at a concept of creating a career track license. So IMGs would not have to go into residency necessarily, but they would always be supervised by a fully licensed physician. So it's the middle ground of letting them practice in Washington while not giving away the whole license, because we feel strongly, along with the legislators, that in order to be fully independent, you do need to go through a U.S. residency. So that one's coming. I think we're going to see some more work with respect to work groups on the specifically the assisted reproduction fraud. That bill calls for work group to be led by DOH, and there's a number of stakeholders. So I think we're going to explore that a bit more. I think the outstanding question, because it does make it a misdemeanor in the bill and it does prohibit it in the Uniform Disciplinary Act, the outstanding question is assisted reproductive fraud, or supplying your own genetic material, is that a crime that's a felony? And I'll just put my bias out there. I think it is. You're without consent supplying your own genetic material. And if you just take away the forcible piece, and I think without consent, that forcible piece is debate. It's really rape is what it comes down to. And most people agree. I think the issue is the politics with respect to what we will see in probably the Senate, and how they're willing to classify it. Other than that, there's all sorts of scope issues that are occurring. So we saw a pharmacist prescriptive authority bill that would effectively open them up to assessment, diagnosis, and treatment, subject to the unilateral rules of the Pharmacy Commission. We had a lot of concerns about that. The state has a sunrise process for scope expansion that we fully endorse, and it works well. The anesthesiologist assistant bill was a result of that, as well as the prescribing psychologist bill, which we ended up being supportive or neutral on once the sunrise review process played out and the necessary guardrails were put in place. So we'll see more of that. We saw the optometrist. There's another bill, I think, coming through about naturopaths and their prescriptive authority, but that one needs to go through sunrise and get assessed as well.
So I know this year it seems that reproductive rights and access kind of seem to be at the forefront of a lot of bills. In the past, opioid prescribing and pain management were really important issues at the legislature. Is there anything happening in terms of pain management treatment that providers or healthcare systems should be aware of?
Yeah, I don't think there's too much with respect to that right now. On your first piece about reproductive care and gender affirming care, there is one bill that's coming forward that's just a cleanup from last session, because last session it was all reproductive rights all the time post Dobbs, and trying to shore up our defenses basically from predatory actions from out of state. And the bill that's coming forward now is just harmonizing what was passed last year. There was one section of statute that didn't get changed identically. It still had the spirit of it, but just the wording wasn't identical, and so they wanted to fix that. With respect to opioid prescribing, we've seen much more in the space of substance use disorder treatment. I think you may be aware that the feds just pulled back the SAMHSA rules on that, so you don't have to, as an ARNP or a PA, you don't have to order through your a supervising physician or a medical director. You can actually order Suboxone on your own. They also reduced the restrictions on letting patients take home Suboxone. I think I'm kind of mixed on that a little bit because Suboxone is not like your standard opioid. Its half-life is much longer with respect to its efficaciousness and how it's actively affecting your body. And that's where, when we first started doing opioid prescribing rules, we were responding to a lot of overdose issues because people are treating Suboxone just like it's an 8-hour pill or something, and it's not. And so you have to be aware of that. And as a prescriber, you really have to be aware of that. So it's good for flexibility. It's potentially dangerous for someone who doesn't appreciate what Suboxone can do. There's also, I believe they did away with the X waiver last year, the year before. So you have to have the special education on opioid prescribing and substance use disorder treatment, but you don't have to have a special waiver from SAMHSA, the DEA. There was a bill we were expecting to come through with respect to sort of a reaction to a Supreme Court ruling that wasn't directly on. So the Supreme Court overruled a criminal act by DOJ against a prescribing physician, and they used a lot of language around the term good faith. And so the effort by pain management advocate groups is to try and insert the concept of good faith into the law in every practice act, to basically say if someone's prescribing in good faith, the regulator can't do anything. The problem is it's really hard to define legally what good faith is. There's no documentation that you can look at to say, oh, this person's mindset was X. And so that didn't come forward this year. I anticipate that it will probably come forward next year. But we're still pretty on the fence as far as staff and the medical commission about what that would mean and the implications of it.
There is an opioid bill that, while it doesn't set any rules or new legislation, it does partner the DOH with law enforcement on an education track. So I think that that's valuable to have a two-pronged approach, both medically and with our, public defenders. And it's not quite the same thing, but there has been a reoccurrence of a psilocybin bill. That's come up multiple times. I would expect that in the future we would revisit that as well. It seems to me that medical practitioners are of two minds about psilocybin, and that the wording has to be very specific. And that's the reason that last year the governor vetoed that bill, but it was reintroduced. It hasn't moved this session, but as we know, next year, different governor, different legislature, it's likely that we will see that one again. And on the abortion front, Micah's right, and the positive, we haven't seen, anything new, any changes, but annually we continue to have bills introduced that seek to punish physicians for carrying out legal abortions in Washington that we have to take a stance against. So those never really make it very far in Washington state, but as we know, neighbor states feel differently. So that often makes compact work for us something that we really need to think about when we enter the compacts and the licenses surrounding the compacts.
And I will clarify on that. Most of our work right now with respect to abortion access, reproductive care, gender-friendly treatment, and compacts is educational at this point. In fact, I'm actively working with New York State and Vermont to explain how Washington has constructed effectively its legal shield, as well as how that integrates with the protections of the compact. The compact has a great one-page, well, not one page, it's about 4 pages, from their general counsel explaining how the 10th Amendment and the Dobbs decision make the compact the best approach to safeguard your licensees with respect to, with the license. geography, everything stops at the border. So with a compact, your Medical Practice Act is what controls. And so if it's not illegal in your state, you can't have action taken on you in that state. And the compact rules and statute make it clear that if someone, say from Texas, wants to take an action against a Washington licensee for performing something that is a Washington allowed service, we do not have to abide by their disciplinary actions. We don't have to mirror it because it's not a violation here. The only thing that would happen is that practitioner would have a National Practitioner Databank report, which unfortunately will follow them around for the rest of their career. But with every databank report, you have the ability as the licensee to provide a response and say, this is what this was. So they can clearly articulate that this was a predatory lawsuit, a predatory disciplinary action, politically motivated, whatever, and make it very clear that it's about reproductive rights. And that can mitigate a lot of the concern of a licensing board who's assessing a new applicant or assessing some discipline. And I will point out that last year we did have prohibitions put in place for the medical commission and other disciplinary authorities to deny a license purely based off of an action of reproductive or gender affirming care. It also denies us the ability appropriately to take a disciplinary action based off of those things if the standard of care was not violated.
Well, I just want to thank you both again for presenting this incredibly valuable information. We will see you later in the session for kind of a wrap up. So if anyone has any questions before then, please reach out to us. Any closing thoughts before we say our goodbyes?
I would just say that one of the benefits of the pandemic with respect to the legislative session is that pretty much everything is virtual and able to be viewed on TVW. You can sign in virtually, you can testify virtually, you can provide comment virtually, and I really encourage everyone to do that. Those comments and positions are noted. They are considered pretty heavily. And if you're a member of the public, truly a member of the public, and not a member of an interest group or a state agency, the legislators love that. They want to hear from you. They want to hear your concerns and your opinions. And so I really encourage everyone to consider doing that if they have time. It only takes about 10 minutes.
Yep, seconded. Thank you, Jimmy. We appreciate the time.
Thank you.
Thank you so much. Thank you, everyone, for attending. Have a wonderful week, and everyone take care of themselves. Take care.
Bye.
Bye.